I don't understand what the majority is saying on this point. And frankly, it's really troubling that I think none of us understands it. And that's really troubling because this is the core of what Judge Chutkan is going to have to figure out.
It's the Lawfare podcast. I'm Natalie Orpett, executive editor of Lawfare, with Lawfare Editor-in-Chief Benjamin Wittes, Lawfare senior editors Quinta, Jurecic, and Roger Parloff, and Lawfare courts correspondent and legal fellow Anna Bauer.
It might end up going up to the Supreme Court and they say, actually, just kidding, all of this stuff we were talking about is absolutely immune.
Today, on the latest episode of Trump's Trials and Tribulations, we discussed the Supreme Court's immunity decision in Trump v. United States and the effects it may have on other cases against former President Trump.
If you were to look at the New York case and say, the New York courts have gone wild, they're just out to get Trump, this is a witch hunt, we must step in and, roll things back, one way to do that is essentially creating a means for yourself to step in and sort of save the day when such a means did not necessarily exist before.
Welcome, YouTube folks and everyone else trickling in on Zoom. Let us begin with Trump Trials and Tribulations for July 5th, 2024. I think we inevitably have to start with the Supreme Court's decision in Trump v. United States, which came out on Monday. And we did, I would say, somewhat shell-shocked emergency podcast that afternoon. So let's start just with a recap for folks who may have missed that. And then we will take it from there to discuss the implications on the trials we've been following. So Ben, can you give a quick high-level recap of what the majority said?
Yes. So the majority, which is a 6 or kind of 5.5 member majority, because Justice Amy Coney Barrett kind of joins for part of the opinion, but also writes separately to kind of sketch out a different rationale. The majority opinion by Chief Justice Roberts creates a 3-tiered system for evaluating claims of immunity by former presidents. The first tier is material within the exclusive and preclusive core of executive authority. He mentions issuing pardons, firing senior staff, as well as some other presidential activity that Congress is disallowed from regulating, and therefore the president has to be immune from criminal process entirely. That immunity is absolute, and that immunity is not subject to congressional or Justice Department or any other kind of court supervision. The second tier, which is of unspecified magnitude in the sense that he says it is at least presumptive and may be absolute, leaving that for a different case, is anything else that could plausibly be considered an official act. So anything that is within the president's official responsibilities is at least presumptively immune and may be absolutely immune. This includes anything within the outer perimeter of the president's authority following the Nixon v. Fitzgerald case. And then the final component is anything that is not official. And of course, the boundaries between categories 3 and 2 are a little bit murky, so we're not really sure what that category is, but anything that is not official, which certainly includes sexually harassing a state worker before you were president. That was the Paula Jones case, but not clear how it would apply to January 6th, is not immune at all. So the final elements of the majority opinion are twofold. One is that anything that is immune is immune not merely for purposes of charging, but also is immune you can't use as evidence of some other crime. And this is very important in the context of January 6th, which of course alleges a conspiracy of which certain acts can either be charged as individual acts or can be, overt acts in a larger charge. And then the second element is very clear that you're not allowed to use motive as any kind of factor in whether a matter is immune or not. And so if the matter is immune, it is immune whether or not it was done in bad faith and with, specific intent to further some kind of corrupt conspiracy, or whether it is a noble act of presidential exercise of power that happens to technically run afoul of the criminal law.
So there's quite a bit to the concurrence by Justice Barrett, and there are two dissents. I think for our purposes, we want to focus on those aspects of the dissents that sort of tease out the main points of contention, because then we want to focus on how all of this has to do with the trials we've been covering, as I mentioned. So Quinta, can you just give us a super quick overview of what the dissents had to say?
There are two dissents. There is one written by Justice Sotomayor, joined by Justices Kagan and Jackson, and then Justice Jackson also wrote a separate dissent. I think the top line here is really just that the liberal bloc strongly disagrees with the majority's interpretation of executive power here. And it's not totally clear, I think, what the liberals would sort of put in its place. Sotomayor at least suggests that there are some instances in which a president could have immunity from criminal prosecution. But the top line of the Sotomayor dissent is really just that, on matters of text, structure, policy considerations, that the liberals simply disagree with the conservatives that immunity, certainly this level of broad immunity, certainly immunity that extends also to motive and the consideration of evidence, is necessary, and that they're deeply concerned about the sort of functional results here in terms of potentially, failing to deter criminal conduct by sitting presidents. Sotomayor suggests that taking a bribe for a pardon, ordering SEAL Team 6 to assassinate a rival, ordering a military coup would all potentially be immune. And Roberts really doesn't rebut that, which I think for me at least was quite striking. The Jackson dissent is more focused on kind of the institutional back and forth here. And her argument is essentially that the court is giving itself power, even as it sort of positions itself as giving the executive power. That what the court is doing, particularly not only by sort of granting the president this broad immunity, but by doing it in such a sort of incredibly complicated way that's going to essentially mandate, just a incredible amount of briefing, interlocutory appeals, so on and so forth, is given itself the power to be the ultimate arbiter of whether or not the president has immunity in any given circumstance. And Jackson's view is essentially that is, even as the court is presenting itself as kind of a caretaker of the separation of powers here, that is in itself a dangerous expansion of not only executive power, but also of the power of not just the judiciary, but the Supreme Court. I think for the cases below, the real takeaway here is that the liberals, as expressed in both dissents, seem to think that the way this opinion is written is broad and uncareful enough that it could be functionally used as a shield for an enormous number of prosecutions. Even if, say, an act is unofficial, maybe it would make it incredibly difficult to prosecute that act because you're not allowed to, look at evidence that is drawn from official acts. You're going to have to go through, round after round after round of appeal. And so the liberals, though they don't say this specifically, I think, about the case at hand, seem to suggest that the standard, such as it is that the court is setting out here, is essentially one that will let Trump off the hook to the extent that it immunizes a great deal of his conduct, or at the bare minimum creates such confusion over whether that conduct is immunized and over what evidence can be used in proving conduct against him that isn't immunized, that it is functionally letting him off the hook.
Okay, thank you. So for practical purposes, the end of the opinion vacates the DC Circuit's opinion and remands for proceedings consistent with this opinion, which, as we've discussed, are sort of a big question mark as to how to begin applying this standard. And that's something that Justice Barrett pointed out in her concurrence. She sort of proposed some additional guidelines on how you would actually go about making the distinction between these three categories. But of course, that's not the majority. So as this goes back to the trial court, a lot of this is going to have to be from scratch. And as Quinta said, it's going to be subject to quite a lot of litigation and going back up on interlocutory appeal, undoubtedly many times. So just in terms of mechanics, my understanding, and folks should correct me if I'm wrong, is that the case should be going down to the DC Circuit, and it should, I believe, according to a Supreme Court rule, take about 32 days to go back there, and then the DC Circuit will have to remand to the district court. I think it is possible that it goes faster than that, but I think that is the general guidepost. Has anyone heard differently from Supreme Court practitioners or elsewhere?
I think the mandate the DC Circuit had created a sort of automatic schedule for the mandate. The Supreme Court did not, which is another suggestion of sort of things slowing down. So I think, absent any reason to believe otherwise, we should assume that the mandate will issue in the usual course of business, which is, not a matter of hours, but a matter of, I think, as you said, 30 days. And then the DC Circuit, which has a bit more of a fire under its butt than the Supreme Court about this, will presumably act expeditiously.
Right. So if that's all correct, we won't know more about what this is going to look like before Judge check-in until August. But let's talk about what we think is going to happen in DC as soon as the mandate is returned. There's this new test. So how is it going to play out? Roger, let's start with you.
Well, I think obviously there needs to be a hearing, and the question is what kind of hearing. And there are hints that it could be something like a mini trial. In the ruling, Roberts says at one point, when he's talking about the category of allegations in the on the day of January 6th, about the tweets and the speech, he says the indictment reflects these challenges, that is, the challenges of distinguishing between official and unofficial acts. It includes only select tweets and brief snippets of the speech Trump delivered on the morning of January 6th, omitting its full text or context. Whether the tweets, that speech, and Trump's other communications on January 6th involve official conduct may depend on the content and the context of each. So bear in mind that, normally an indictment, it doesn't have to be a speaking indictment. An indictment could be basically just tracing the language of the statute. It could be like 3 or 4 pages in this case. Instead, it's quite a lengthy indictment, and he's saying that's not enough. Going through that is not enough. We need more information than that. So that begins to sound like a trial, and it may be that, a mini trial. It may be that the government decides this court is not permitting this to ever go forward. The best thing we can do is have a mini trial. They won't, I say that to themselves, obviously, but there is ample basis in the decision to think that that's the only realistic way to go forward, especially because you also have this footnote 3 and Roberts' view that you can't even use official conduct to prove unofficial acts. Generally speaking, there's an unintelligible exception to that, but that is the general rule. And then also you need to have prior pretrial review. So it seems to me that, we were talking about a 6-week trial. It's already a little shorter because we cut out the DOJ charges for sure. But it's about a 6-week trial. So you're talking probably about 1,000, maybe 500 to 1,000 exhibits planned. I don't see how you can use any of those exhibits under this ruling until somebody has ruled whether they involve official acts or unofficial acts, and are they the kind of unofficial act? Can we use them as evidence and allow an opportunity for appeal? And of course, normally the prosecution would hate this. This is sort of like what's called the preliminary hearing in some states, where you need to put on all of your evidence and let the defense see everything you got. It's sort of the most expansive discovery tool imaginable, and prosecutors normally hate it. If they ever plan to really go to trial, they would hate it. I don't think they can. So the mini trial becomes attractive, and it's also the only way to take this ruling seriously. So I think that's sort of where we're going, but I also think Trump will try to stop that, and this court could somehow intervene. But anyway, that's where I come down.
But one point here, Roger, I think if I'm understanding you correctly and referring to the unintelligible exception, there is this incredibly weird footnote in the majority opinion on this section about evidence, where Roberts says the prosecutor, I should say, of course. What fools we were to think it could be otherwise. The prosecutor may point to the public record to show the fact that the president performed the official act. So you can't use the official act as evidence, but you can use the public record of the official act. I think again, Roger, if I'm understanding you correctly, I agree this is unintelligible. I don't know what that means. So to use an example that Ben and I were tossing around, what if the president at the State of the Union, so State of the Union is a constitutionally, it's prescribed to the president only. This president says, at the State of the Union, with this sentence, I am ordering SEAL Team 6 to assassinate, my political rival. Can you use that sentence that he said, or she, we can have our hypothetical criminal president be female. Can you use that sentence as part of a prosecution? There's going to be a public record of it. You can watch it on C-SPAN. You can read about it in the newspaper. But it is a speech act. It is the official act of giving the order at the State of the Union is an official act. Can you point to that? I genuinely have no idea.
I think the issue is even more complicated than that, and you don't need to reach the extreme hypotheticals like assassinations ordered in the State of the Union address. Let's take a real example that affects the New York case very immediately, which is Trump threatening Michael Cohen or menacing Michael Cohen by tweet. So there is evidence that shows up in the New York case where, Trump engages in this full court press against Michael Cohen when he shows sign of flipping. Now, you could say this is wholly immune because it's presidential speech, so it's at least presumptively immune, and the Twitter feed has been held to be some kind of official thing. But you could also say, wait a minute, under that Roberts footnote, and under logic number one, you would say, well, you can't apply the evidence, not merely as you can't charge him with some illegal tweet, which of course would be constitutionally infirm anyway, but you can't use the evidence of that to prove some other crime, which is exactly, by the way, what happened in New York. the other way to look at it would be, wait a minute, under that Roberts footnote, you can't use the fact that he sat there and punched the tweet. You can't make him admit that, which would be Fifth Amendment protected anyway. And you can't get some aides to say that. But you can use the evidence of the public act, as in the Twitter feed, to prove that. Well, I'm not sure, first of all, what the difference is. I'm confident that Roberts did not think about that as highly, I think, of his intelligence. It clearly is something that he did not consider. And the result is that it's completely unclear what the implications are of that tweet for the New York case. And I'm sort of bewildered by it. I think he must mean that you can use the fact of the public evidence. But if that's the case, it really isn't immunity. What he's talking about is executive privilege, that the confidential deliberations are unexplorable. If you think about the analogous situation in speech and debate immunity, if, Senator Mitch McConnell goes down to the well of the Senate and releases all kinds of classified information, you can't use the public evidence of that, which is to say the congressional record of Mitch McConnell making a floor speech reaching, the public evidence of that is precisely what's immune. And so I don't understand what the majority is saying on this point. And frankly, it's really troubling that I think none of us understands it. And that's really troubling because this is the core of what Judge Chutkan is going to have to figure out.
I also wonder to what extent this exception that he carves out even is one that maybe narrowly applies to bribery, in the sense that bribery, the statute actually includes the term official act. And so he's saying, because as a part of, proving up the statutory, what you actually have to show, then yes, in that case, you could introduce the public record to show that the official act was done.
But Anna, how can Congress override the constitutional privilege, if there is a constitutional privilege, merely by including the words official act in a statute? If it's not immune for purposes of the bribery statute, then it's not immune. And I
think the special problem.
I agree.
I think the special problem with bribery is that he has to admit that the president can be prosecuted for bribery because it's right in the impeachment clauses. So he's stuck. He can't give immunity for that. So here is his response. But I think Anna's right that we don't know how broad this footnote 3 is. I do think it seems to, my best guess is that it does allow public records, but the use of public records, the trouble is most crimes aren't committed in the public record, at least, and I know some of Trump's are, but most aren't. And the rest of that footnote goes on to say things like, what the prosecutor may not do is admit testimony or private records of the president or his advisors probing the official act itself. And then he says this crazy thing about, that would second guess their propriety. That would invite the jury to inspect the president's motivations for his official actions, which is, of course, every crime involves inspecting your motivations. The overriding thing is that this whole opinion doesn't look at the reality of proving a criminal case. The government has the burden, and you need to eliminate reasonable doubt. And this creates a Swiss cheese of, you're trying to prove a whole, and there's a ton of things you can't use. And you can't even explain to the jury why, because, that would, there's no mechanism for it. The defense typically says in summation, if you feel like, to feel comfortable convicting, you have a reasonable doubt unless you have a certain piece of information, then you must acquit. And they're allowed to say that because that's the normal rule. Here, there's going to be 1,000 things missing, and nobody will be able to explain why. You can't give an instruction saying, the court has said we can't use a whole lot of things. That would violate, the burden of proof and the Fifth Amendment. And anyway, so as a practical matter, I don't see how you proceed in this situation.
One last thing on this, just really quickly, is that if it is the case that this exception applies very broadly to where you basically have a kind of public records are able to come in, even if they otherwise would be immune, then why would the court go through the bother of talking about how the district court needs to look at the public tweets and public statements and decide whether or not they are immune in the first instance? So I'm not really sure. It's totally inconsistent and incoherent to me. It's honestly, it's just a mess.
Go ahead, Quinta.
So yeah, just one point that I wanted to make here that I think was a framing that was suggested to me and which I found kind of clarifying is that if you read the Justice Department briefing here, both at the Supreme Court and in the lower courts, what the Justice Department is essentially arguing is we don't need to find any immunity because there are all of these different mechanisms by which the president can be protected from, a meritless prosecution, ranging from, I'm not sure if they pointed to executive privilege, but you could argue executive privilege is there. You can make an as-applied constitutional challenge to the application of the specific law to this specific conduct. You could point to the Office of Legal Counsel's clear statement rule, which essentially says that if the president isn't directly identified in a statute, you should assume that it doesn't apply to the president. There are a range of kind of different ways to understand that. And I wonder whether different protections that the Office of the Presidency provides, essentially. And one way to understand what Roberts is doing here is to essentially take that bucket of stuff and say, okay, yes, also now all of that is immunity. So that you have, something that normally would be protected through executive privilege, but then it's now an immunity. So now we have this weird evidentiary problem, whereas previously we could have just hashed it out in executive privilege terms, or, thinking about the application of the obstruction statute to this specific conduct. And I think that what that does for Roberts is it kind of cuts things off at the pass and means that the courts get to consider all of these issues, before the case actually goes to trial on an interlocutory basis and so on and so forth. So it has the effect of producing delay, without speculating on motives here. But I think it also creates just a lot of strangenesses because there are obvious ways that you could implement these various principles in practice over the course of a criminal trial, that we know what they look like. But if you make it an immunity, then you end up with all of these bizarro, situations where it's just not clear how to implement it in the first place because you kind of shifted how it fits into the broader system.
Yeah, I mean, one thing that I do wonder is whether the majority has left any space for the use to get around some of this messiness with respect to potentially presidential but public record matters for the purpose of determining which category behavior falls into, as opposed to the second step of using that to prove criminality, which I think, we'll have to see. And then there is also very clearly a strategic question as to whether you want to sort of make that argument as the prosecution or even as Judge Chutkan, because that will inevitably go up on interlocutory appeal. And so will everything else. But do you want to sort of start there? What will that do in terms of what evidence you can use in the mini trial, which, given the timing we're talking about, the mini trial is where we are going to get maybe some discussion of the facts, which will potentially have a different sort of impact on public understanding of what's happened, given that we are not going to get to actually adjudicate guilt or innocence, but maybe that process of the mini trial will be meaningful. I want to switch, unless anyone else had something to add on this, I want to shift over to what this means in very concrete terms, starting with New York, where Justice Merchan has delayed Trump's sentencing, which was supposed to be this week, to September. Who wants to take that one? Anna, do you want to take a stab at that?
Right. So, look, a lot of the conduct took place before Trump's presidency while he was a candidate for office. But I do think that there are some issues here in that there was a lot of evidence that was brought in at trial that has to do with Trump's what was going on while he was in office. Of course, he signed some of these checks while he was in the White House. There was testimony from Madeleine Westerhout, for example, who was one of his executive assistants who sat, right off the Oval Office, who talked about the president's work habits in terms of whether he, paid attention to everything that came across his desk, the fact that he was signing lots of official documents. There was evidence of, as Ben mentioned, these kinds of public statements that Trump was making while he was the president, which very clearly in this opinion, the court emphasizes that a president's public statements about matters of public concern are typically, although they can be unofficial, typically will most of the time be official acts. And then I think most concerningly, though, you have things like, for example, the government ethics form that was filled out during Trump's presidency. That was a big part of the prosecution's evidence. And then you also have the testimony of Hope Hicks, who had at least, as I see it, and Ben, correct me if you think you have a different understanding, but I think that a part of the evidence that was very important to this prosecution dealt with this White House meeting between, at the time, Hope Hicks, who was the communications director for Trump, had this meeting about an article that came out about Cohen paying for the Stormy Daniels hush money deal. And Trump has this conversation at the White House with Hope Hicks, one of his top officials. Again, the court emphasized that confidential communications between the president and his advisors, that would include someone probably like Hope Hicks, and on speaking on issues about that are matters of public concern, those are things that seem to, in the court's view, maybe be official acts that would be at least entitled to presumptive immunity, which the prosecution can potentially rebut. But that testimony about that meeting and what Trump said to her, which was, to the effect that he thought it was better that the story was coming out now than what it would have come out before the election. So that's a potential issue in that the prosecution is likely going to have to rebut that presumption of immunity. And Justice Merchan is just basically going to have to go through all of this stuff. There's also the things about the communications between Michael Cohen and Bob Costello about, for example, maybe a potential dangling of a pardon kind of thing. There's the whole plot line that had to do with whether Michael Cohen was going to become attorney general during the next administration, stuff like that I just think Justice Merchan is going to have to go through. And then I think he's going to have to decide whether there's prejudice and whether basically he needs to have a new trial. So, but Ben, jump in and tell me what you think about all of that.
No, I agree with that completely. I would just add one thing to it, which is that you can assume that we adjudicate that Justice Merchan and the New York State court system adjudicate all of these questions in the fashion that is most favorable to the prosecution. And they may not do that, but they might, right? So each of these matters becomes sort of personal conduct or worst case scenario, official conduct that you probably should have excluded, but there's no prejudice because the jury had so much other evidence, right? The one thing this unambiguously does is create a federal question for the Supreme Court to review the New York Court of Appeals. And so the relevant question, that didn't exist before. The strongest aspect of the New York case from the point of view of Trump accountability was that the Supreme Court would really have to stretch in order to find a federal question on which to get involved. And so it really could be done, by the way, unlike the Georgia case, which raises all kinds of federal questions and is in federal court because of removal stuff already as a result of that. The New York case was a kind of pure, the federal questions associated with it were really minimal. Now they are not minimal. And, you're going to see this almost guarantees, I think, a federal Supreme Court appeal on direct appeal at the end of this litigation in the New York system, and probably rightly so, assuming the integrity of the underlying decision, because, the Supreme Court just sent down a bunch of mush that they're going to retroactively want to apply to a dozen or more, as Anna rightly points out, trial court decisions. And since they've given us and him so little guidance as to what constitutes protected immune conduct, really the question is whether 5 justices agree with Justice Merchan's application of that, since there's no way to know prospectively what the right adjudication looks like. So I think it creates real problems for the New York case in the short term. If we assume the New York courts will err on the side of the conviction, I don't think we should assume the Supreme Court will. So in the long term, I think it poses real dangers for the New York conviction.
Can I add one point here? Yeah, thank you. I completely agree with Ben about that. And just to point to an article that I thought was really clarifying on this score, the New York Times has an op-ed today by Will Bode, who's a law professor at the University of Chicago Law School, clerked for John Roberts. People may be familiar with him in this context specifically because he co-wrote the law review article that sort of put a fire under the 14th Amendment litigation, arguing that the 14th Amendment did indeed disqualify Trump from serving as president after his role in the insurrection. And what I found interesting about this op-ed is that it suggests that, and let me pull this up, the court is, I think Will's article suggests incorrectly, understanding itself as, and I quote, trying to save the country from other institutions' disproportionate responses to Mr. Trump. It believes that the lower courts and the Justice Department have succumbed to a version of Trump derangement syndrome, which is said to affect so many liberal elites and even never Trump conservatives. And then the article goes on to essentially suggest that the court is sort of seriously misreading the situation here. But I think that there's a lot to that argument. And I think I also find it clarifying if you think about the Supreme Court in relation to the New York case. Because if you take the view that what may have been animating the majority here, or at least the 5 justices minus Justice Barrett, who signed on to the majority opinion in full, if you were to look at the New York case and say, the New York courts have gone wild, they're just out to get Trump, this is a witch hunt, we must step in and, roll things back. One way to do that is essentially creating a means for yourself to step in and sort of save the day when such a means did not necessarily exist before. So the op-ed doesn't specifically mention the New York case, but I did find it clarifying to sort of read it alongside these proceedings.
Just one thing to add to what Ben was saying, that even if Justice Merchan were to rule for the people on all of these questions, which, as Anna points out, seems challenging. Then the question is, do all of these appeals occur in an interlocutory way before you even proceed to the sentencing? And I think they do. That's how I read it. So it's a huge block.
Okay. And just for next steps, procedural purposes, where I believe we are, but correct me if I'm wrong, guys, is in New York, at least some justices in state court have a somewhat odd process of writing a letter to the justice or to the judge to request permission to file a motion. I think so. The letter is in from Trump's team. It went in on July 1st. I believe that Justice Merchan hasn't officially given them permission to file the motion. I am pretty confident that we haven't seen any response from the government yet. Does anyone know differently?
Well, there might be a response, but we just don't know about it yet because of the weird way that the docket works in New York. So but I have not seen any more further movement. Although, correct me if I'm wrong, Roger.
I thought he had permitted it because that's why he moved the sentencing. He moved the sentencing off till, I think, September 18th or mid-September to allow this
the briefing.
Oh, yes. I thought that Natalie meant we haven't seen further substantive briefing on the issue.
Okay.
No, that's correct.
Yeah. Okay. So, I mean, it is also worth noting that the state government, state prosecutors in New York are going to be the first entities to make some of these legal arguments directly in response to this motion series, which will happen on a official basis.
Trump hasn't even submitted his full motion yet.
Right. So it will still be a little while, but I expect it will go faster in terms of when the New York prosecutors file their response to Trump's motion. Then we will see the initial briefing in DC. So we will keep an eye out. Let's talk quickly, and then I want to move over to questions soon about the implications of this case in Georgia, which we touched on a little bit. Anna, you want to talk about that in the first instance?
Yes. So look, I think I'm still doing a exhaustive review of that indictment, which is a quite long indictment. And so I think it's going to take some time for me to really wrap my head around all of the things that may be subject to coming out. But most immediately, with the DC indictment, you have issues with any part of the case as it relates to Trump, at least, that is in relation to the Jeff Clark charges, the draft letter that Jeff Clark tried to encourage top DOJ officials to send to Georgia's legislators, saying basically, we found evidence of fraud and we want you to call a special session to potentially appoint different electors than those who were elected on behalf of Biden. That is going to be a big issue. There's also, keep in mind, elements of this that relates to the voting machine breaches. And as a part of that part of the case, well, I think that the Coffee County stuff, which relates to people who were trying to gain what they called and what Rudy Giuliani had described as, quote, voluntary access to voting machines. There's a different aspect of the case here that relates to these potential plans to seize voting machines by using the military, for example. And there are these draft executive orders related to that plan. And that's in this indictment here, that those draft executive orders mention specifically Coffee County, which is the place where eventually third parties went in and did access and take information. So I think that there may be a problem as against Trump with that aspect of the case. There's the plan to appoint Sidney Powell as special counsel. All of that kind of stuff is going to be an issue as it relates to the case against Trump. Then you have these other, questions that are raised as they are in the DC case about the conversations with the president. the vice president. You have issues with Trump's conversations and meetings with state officials. Those are all areas where the Supreme Court has sent it back to Judge Chutkan. And so Judge McAfee is similarly going to have to do a very similar analysis when that case eventually does, and if it does, get back to him sometime probably in the spring of 2025. We raised this question on the live last week, or whenever we did it earlier this week in the wake of the opinion. But I will just say there is this looming question of how all of this affects the case against other individuals who are subordinates, like Jeffrey Clark, and then how it affects the broader case against other people in the alleged RICO conspiracy. Here, I think at the very least, this decision means that Trump has to be severed out. And then a lot of the areas that I just discussed would have to be stripped from the indictment and stripped from the evidence as it relates to Trump. Not a great thing for the prosecution because they wanted to try everyone together. But at the very minimum, Trump would probably have to be severed. But there is still this lingering question about maybe could an evidentiary privilege be raised by some of these other people, even though they are not the president? Can they try to get some of this evidence out as it relates to things that would be stripped from Trump's indictment as well? And then finally, let me just say before Quinta jumps in, Fani Willis is going to have to decide if Trump wins, whether she wants to, of course, if he wins, the federal prosecutions go away, but she is previously indicated, or at least Nathan Wade has after his tenure as special prosecutor, that he thinks that there's no reason why the state prosecution against Trump could not proceed, even if he is elected. At the very earliest, 2025 would be when that case goes back to Fani Willis. But at that time, if Trump is president, she has to decide, will she try to put him on trial, and that eventually is going to go up to various higher courts, because it seems like, as we've discussed before, it seems really unlikely that the court is going to say, yeah, sure, put the president on trial during his presidency. Trump would have a very good argument that she has to wait until 2029 when he's out of office.
So to point to an additional area of sort of quasi-Trump trials that I think might be affected by this, that has to do with bar discipline proceedings. So there have been a number of lawyers involved in the effort to steal the 2020 election who have been facing discipline proceedings. I think at this point, there have been recommendations at various points in the proceedings that they be disbarred. So that's Jeff Clark, Rudy Giuliani, John Eastman. The disbarment isn't official yet, I don't think, in any of those instances, but it is moving through the process. And I did have a conversation with someone who suggested that they would not be surprised if these three people sort of introduced the court's reasoning here as a reason why the disbarment recommendation should be ruled back, because the evidence in question is drawn from something that could be an official act. So that doesn't mean that it would succeed, but I do think that it is worth underlining here just how fuzzy the court's language is. And just how much leeway it potentially gives to people who are sort of trying to throw sand in the gears of various efforts to hold people who sought to steal the 2020 election accountable, even those efforts that are in state court, whether in the New York criminal proceedings or in these bar proceedings in state court, in states overseen by state courts in DC.
All right, let's do our last trial, which is in the Southern District of Florida. We did do a little aside in our Monday podcast about how Justice Thomas's very strange concurrence seemed to have been a direct message to Judge Cannon with respect to the question of whether the special counsel is constitutional, which is a pending motion right now. Anna wrote a very long and good dispatch about the hearings in that matter. But who wants to take what does this do to Florida?
So there are specific references in the Florida indictment to things that happened before the end of when Trump was still in the White House. So those need to be looked at. I can't find my notes on that right now, but they typically have to do with the fact that the government is arguing that he knew about these boxes beforehand. He knew what was in them beforehand. He played a role in packing the boxes, and he caused them to be taken out of the White House. Bear in mind, he did already move back in February to dismiss the first 32 counts on grounds of presidential immunity. The 32 counts are the willful retention of national defense information. The idea was that he had caused them to move, and the idea was the motion uses strange language. It says that he allegedly declared them as personal by having them moved out. Obviously, the indictment doesn't say he allegedly declared them personal property. So, but the claim is going to be that he tried to. The claim already is that there was an official act under the Presidential Records Act by the very act of moving things outside of the White House, which is a crazy argument, but it's one that she has almost already accepted. But in addition, we've gained a lot of from the motions. We've now seen a lot of the government's 302s, the evidence that they plan to use, what the witnesses are going to say. They have witnesses from the White House. They have a White House Office of Records Management official and Trump's own staff secretary, who became very concerned during the administration that he was hoarding these boxes in a weird way in his residence, next to his bed in some cases, and that how were they going to get presidential documents to stay, to go to NARA? How were they going to comply? And there are long discussions about this, and some of the beautiful mind discussions about how strangely attached to his boxes he was. This is important proof in terms of the notion that, it wasn't just a matter of somebody else packing these up and whoops, classified documents were among them. Who knew? Which is a hugely important defense if you can't disprove it, and you may not be able to disprove it at this point. So that's the main impact I saw.
Yeah, and just to follow up on that, I will add that, and Roger, my internet cut off for a minute, so apologies if you already covered this, but keep in mind that when Judge Cannon was asking the parties for input on those proposed jury instructions, there was a part of those jury instructions, as she asked them to engage with, that basically said, it's the government's burden to show whether these records were personal or, presidential. And so it's kind of like, how are you supposed to show that the records were not designated as personal if you can't actually bring in people to say, yeah, while he was in office, Trump never, designated, I never heard him say anything about designating these as personal, blah, blah, blah. Of course, they have this argument that just simply the act of causing the boxes to go to Mar-a-Lago was sufficient. Also, keep in mind, Trump has not explicitly argued this through the pretrial motions, but for a long time, especially in the early stages of this case, he had publicly been claiming that he could declassify with his mind, that kind of thing. There's evidence that, according to public reporting by places like ABC, Mark Meadows is one of the witnesses in the case who testified that he never heard Trump, say anything about declassifying. So there's things like that you would think the prosecution really wants to get in, Then there's also the element that it just the genesis of the story of NARA being concerned about not getting presidential records at the end of the administration. There's all this internal stuff. There's also just the very fact of a president receiving declassified documents that are at issue here. Surely you'd have to have a witness, or you'd want a witness to be able to testify to the fact that at some point Trump had received those classified documents, maybe that people knew that those were documents that were important to him. As Roger said, there's some testimony or references to testimony about how certain documents were seen as particularly valuable to Trump. He didn't trust the system that was, of records management, that kind of thing. I mean, all of that is really, really relevant proof here that you might not be able to get in, and especially with Judge Cannon. And there's even this question of, like, for example, some of these classified documents they say has writing that Trump's own writing that he wrote, like notes he took as president on the classified documents. So it's like, do you have to redact that on the there's just all these weird questions that are going to arise, and it's Judge Cannon. So even though the higher courts, the appellate courts will have their own say when this goes up on appeal, I just think we're going to get a lot of really weird rulings, and it's going to go on and on.
And just following up on what Anna's saying, and again, getting back to the proof beyond a reasonable doubt, the practice of it, they would have had witnesses who were in a position to say, these were not classified, declassified before it left the White House. They would have put that in. Now there's a sub question here we don't know the answer to, is whether the defense, if it gets as far as going to trial, which seems increasingly inconceivable, if it does, and say he brings up, I declassified them. He opens the door. Does open the door mean anything in an immunity case? Of course, it would be unfair not to let the government call people in to say, but all of this is unfair. Immunity is unfair. You're letting criminals go. So why would opening the door matter?
So I would just like to wrap this whole depressing discussion up with something cheerful, which is that in exactly the way that I'm sorry, I just confused you, Roger, with John Roberts for a
slander.
In exactly the way that Roger just suggested, it is really important to remember that to say somebody is immune is not to say that they are innocent or have been vindicated. If a diplomat goes out and shoots somebody on Fifth Avenue, they are a murderer. They just can't be adjudged to be a murderer because the immunity conveyed by the Vienna Convention deprives courts of jurisdiction over them. It's not that they didn't do it. It's not that they're not guilty of committing a crime. It's that they are not subject to our courts' adjudicative powers. This doctrine says the same thing. So I think about the president in a complicated sort of way. And so I think it's really important to remember that one thing this does is it prevents Trump from ever being acquitted, ever being absolved, ever finding that the indictments are legally defective, save that they, tried to subject him to criminal process at all. And so I think one consequence of this is that we are all free to consider Donald Trump to be a criminal on any of these charges that we like. And I actually think that's an important component of the holding, or a necessary corollary of the holding, that to say somebody is immune is not to say that they're innocent. And you are now entitled to say, I am going to assume that the government could prove all of these allegations in all of the various governments, could prove all of the allegations in all of these indictments true. And the former president may not be amenable to criminal process, but that is very different from saying that he didn't do it.
All right, we are going to shift over to questions, and I'm going to start with David Mayer, who actually was asking some questions on this theme. So David, go ahead and unmute yourself if you are there.
Oh, yes, thank you very much. Got to get my cat out of the way here. Yeah, and you guys have touched on this a little bit, but I'm interested in the downstream effects of presidential immunity. As Ben just mentioned, it doesn't mean he didn't do a criminal act. It just means he can't be found guilty for it. What of all the poor schlubs who work for the president who have been ordered to commit illegal acts? If he does send SEAL Team 6 to assassinate an opponent, in the military, it's you can't accept an illegal order. Does that make them subject to military justice? I think you touched on this before. I don't know how this could affect bar discipline proceedings. If an attorney at OLC is ordered to issue a clearly non-legal and probably unethical decision, is that attorney then subject to disciplinary proceedings? Who would ever want to work for the president with this kind of immunity? It boggles the mind.
So, look, you're absolutely right. First of all, the immunity is personal to the president. There is some indication in cases involving speech and debate clause immunity that it may extend to some degree under some circumstances to congressional staff. There is no indication in this opinion that the immunity here extends beyond the president personally. That means when you're dealing with a criminal president, and I have no reservation about saying that Trump was and can reasonably be expected to be a criminal president. I would normally say alleged in front of that, but now that we have no means of adjudicating that, I think I'm entitled simply to do that as a matter of ipse dixit. The consequence is that the question is exactly right. You have to operate as a staffer or as a member of the military on the basis of knowing that the orders that you get may be unlawful and that you are accountable for violating the law, but the person issuing them is not. And that means he can direct you to do all kinds of things that he has no accountability for, but you very much do. So this creates, I think, two problems. One is that he is unbound, but you can't assume that you are. And that puts a premium on his use of the pardon power, both prospectively and retrospectively. I.e., he wants you to do something illegal. You know it's illegal. He knows it's illegal. You know that he knows it's illegal. Your willingness to do it may very well depend on his willingness to extend his immunity to you, which he can do, but he has to do. The second problem is that in the absence of that, there will be a real instinct on the part of a lot of litigants to extend the immunity. And this is, I think, Quinta's point about the bar disciplinary proceedings. On its face, there is nothing about this opinion that gives immunity to anybody but the president. If you're John Eastman or Rudy Giuliani and you were giving deficient, lawless legal advice, you are still subject to bar discipline for it. The question of whether what happens in Vegas stays in Vegas, however, is not a trivial one. And there will be endless arguments over the next few years about whether if I was helping the president do something that was an official act and that you can't prosecute him for, am I really touchable either? And I think the instinct to extend this beyond will be non-trivial. The opinion itself does not do that. I think we're going to have lots of requests from lots of courts to probe the boundaries of that.
Well, if I may ask just to supplement then, what do you think the effect of this will be on Meadows' removal action?
I think first, I thought the district court and appellate court opinions in that case were suboptimal to begin with. I think the case for removal was much stronger than, but it's going to have to be redone at this point because the court's opinion about what constitutes an official act and the district court's opinion in the Meadows case about what constitutes an official act are not harmonious with one another. And that means that as a preliminary matter, I think Mark Meadows is going to get another chance to argue this.
Yeah, I think the other thing that's a little amusing about this, amusing is, I'm not even sure what choice of words, but if courts were to determine that this rule does not apply in other cases and the immunity is purely for the benefit of the president or former president, is it then possible that after that same evidence is used in another case whereupon it becomes public record that it can be then used against the president? We don't know. Roger, you had something to add to the previous?
Yeah, and I hope I don't get this wrong, but a crucial, if we assume good faith on the part of the 5 or 6 justices who wrote this opinion, the main thing they were worried about was a cycle of vindictiveness, like protecting former presidents. And if the 11th Circuit, it seems like the 11th Circuit ruling that, the removal statute doesn't apply to former officials, that just has to be wrong. That if Biden were indicted in Texas for his border policy and he can't get out of Texas, that can't be given this ruling. I mean, the whole point is to protect former presidents. And so either Congress has to quickly change the law or that part of the 11th Circuit ruling has to be overturned.
Yeah. And so, I mean, I think that that's going to be a big issue, regardless of whether this case turned out the way it did. It was already a very odd statutory interpretation that the 11th Circuit did in that respect. But I will just mention that there's 2 different things going on here. Is that there's a removal statute that is the way that Mark Meadows' claim is operating under. So there's going to be more statutory or interpretation questions as opposed to the court inventing something out of, not inventing something, but, coming to something in a novel question like presidential immunity for a former president who committed criminal acts. There's also a lot of more jurisprudence on supremacy clause immunity, which is the federal defense he raised under that statute. I think it's very likely that we probably get a revision of the supremacy clause immunity test, which is very important because that's an affirmative defense that Meadows has raised in Fulton County. And one reason I say that is that under the supremacy clause immunity test, there is a subjective prong in which the federal official basically has to subjectively believe that what he did was necessary and proper, within his federal duties. So I think that there may be some revisions to that test, which has been one that has been, quite longstanding. And there's a lot of case law, not a lot, but certainly much more case law in the supremacy clause immunity context than there was in the presidential immunity context. So whenever that does go to the court, which I think it will when Meadows eventually files his petition, I think that it's very likely we may see some revisions in which the court goes towards a more objective test for supremacy clause immunity and gets it more in line with maybe the way that it formulated its presidential immunity official, unofficial acts test.
Quinta, you had something to add, or did I?
Yeah, this just a quick point to go back to the question of, who would want to work for the president if they're potentially open to prosecution for things that he is not. I think one important thing to keep in mind here is, the types of people who go into different administrations. So the first Trump administration saw a lot of the people who kind of fashioned themselves as the adults in the room, so to speak, like Don McGahn, White House counsel. And those were the kinds of people who were saying, we can't do this, we can't do that, right? That's illegal. That would be wrong. If you read news reporting, the Times has done some really good reporting on this. There is a concrete effort by organizations aligned with Trump heritage, and there's one other whose name I'm forgetting, but it's a sort of specifically Trump spun up program to essentially identify and recruit people who will be more in line with what they see as the Trump administration's priorities, and that Trump himself is much more focused on finding people who will do what he wants to do and appoint those people to political offices. So I do think it's worth keeping in mind, if you have if you imagine like Joe Biden suddenly decided that he wanted to drone Trump because he would be immune, I think you can pretty easily imagine, the people around him on the National Security Council, White House counsel's office, so on and so forth, resisting that because, it's wrong and they don't want to be prosecuted. I think the danger is if you imagine a situation where there's not only a president who wants to do such things, but is surrounded by zealots who really believe in the cause, are confident that he will pardon them, don't care if they're prosecuted because they think that, it really matters, and so on and so forth. The other thing is that I think this is where the professionalization of the military really matters. We have a professionalize, the higher echelons of the military that are, people who take their obligations, their oath very, very seriously, take the UCMJ very, very seriously. And so I do think that there's, if you have environments where there are sort of people who have institutional obligations that are not to the individual president, and who are conscious of, systems of accountability like military justice, like the criminal courts, that they could be held accountable to, that might be actually less concerning in those contexts.
Okay, we're going to try to get to as many questions as we can. Lindsay, I am bringing you on.
Thank you. So I know that this conversation has been primarily focused on the immediate implications for Trump's trials, obviously given the name. But I'm wondering if I could ask you guys to think long term about this decision and putting my cards on the table. I think it's like historically bad and, really compares to like a Plessy or a Dred Scott decision, which took decades to undo, or an amendment. And I'm just wondering how you guys are thinking about what long term that looks like for this case, if possible.
Sure. Ben, you want to take that one?
Sure. Look, it is not morally on a par with Plessy, and I don't want to, it's an institutional separation of powers decision, not a oppress people. So I don't want to put it on a moral plane with the Supreme Court's worst moments. It is a highly destabilizing opinion vis-a-vis the separation of powers, in my view, and one that in a world in which we are worried about presidential authoritarianism is very damaging. I think there are only two ways to think about undoing it as a functional matter. One is change in composition of the Supreme Court, with one justice in a different orientation. You would have had a much better opinion if Justice Amy Coney Barrett's opinion had been law. I still think it would be a bad place, but it's a much less bad place. The second is constitutional amendment. Obviously, that requires overwhelming congressional majorities that don't exist. I think realistically, in the short and medium term, we are going to live with this, and that means we have to have people to prevent presidential criminality. You have to have people in the Oval Office who are disinclined to it, not people in the Oval Office who are inclined toward it. It's not that, it's legal for them to do things. It's just that compliance with law is entirely voluntary at this point. And I don't think there's any way around that at this point, except don't elect people who you're afraid are going to violate the law.
Okay, Mike McNeely, please go ahead.
Well, I was thinking about what Jack Smith could do. And one thing it led me to is the question, well, is he bound by Roberts' evidentiary ruling in a mini trial? Because Roberts justified that ruling largely on the basis of the jury not hearing this stuff. Well, they wouldn't in a mini trial.
Yeah, that was a point that I raised earlier, that I think the opinion as it stands does leave room for that. Because, as you say, a lot of the logic relates to the jury, but it's not exclusively about the jury. So I don't think we know. And undoubtedly, that'll, as I said, be a strategic question as to whether the prosecution wants to argue that and whether Judge Chutkan wants to find accordingly, because it will certainly go up on interlocutory appeal. Anna, I'm sorry, go ahead.
And I think also that it's going to be hard. I mean, to the extent opening the door is possible, it's going to be hard for the defense in the Washington case not to open the door if they want to press their case for a broader immunity. I mean, once the evidence is there, they got to talk about the things that are supposedly immune. And it would be totally crazy if they could say something about it, but Jack Smith could not.
I don't think that the evidentiary stuff applies at a mini trial, though I do think that one of the restrictions would be, because the purpose of the mini trial is to determine whether the acts are official or unofficial, you would have to keep it pretty narrowly limited to, for example, not including testimony about motive, the things that the court kind of set out in terms of what can't be considered by a court in determining official versus unofficial. But it seems to me, reading this opinion, that it does seem like there are times maybe when the court is saying that briefing is sufficient. Maybe that's just on the areas where they have already determined that there's presumptive immunity, but there's other areas where it seems like they are saying you need more facts to determine whether this is official or unofficial. Been pointed to in the public statements, for example. One thing that stood out in my mind was where Robert says something to the effect of, like, who sent the tweets might be something that is relevant, that kind of thing. So I think that you kind of necessarily, if you are going to have an evidentiary hearing, it seems like things that might later be determined to be official and presumptively or even absolutely immune could still come in at that hearing, because the purpose of it is to actually hear all the context and all of that. And it's not before a jury, which is kind of one of the purposes of this immunity, is that the president doesn't have to answer for or be convicted of conduct. But if it were the case that the court felt so strongly about any of this evidence coming out, then and it's about something other than whether a jury is going to render a verdict on it, then why doesn't this immunity apply in, for example, congressional hearings or other types of non-criminal hearings, right? So
Anna, don't say that. That's going to be the argument that OLC makes next.
Okay.
Anyway.
I'm going to read a question for Josh, who asks, is there really nothing that can be done in the DC trial? E.g., could Jack Smith move to file a new indictment given the immunity ruling, and could Chutkan consider that? So the answer is yes. Jack Smith can file a superseding indictment, could file it with specific language as to why something is an unofficial act, and try to go from there. I mean, one question I've always had is, because this is a motion to dismiss, the facts as alleged in the indictment have to be treated as true. So procedurally, it is an interesting question as to whether a superseding indictment would allow Judge Chutkan to rule as a matter of law, at least on certain aspects of the indictment. I am going to turn it over to Matt C. Matt, please go ahead.
Yeah, regarding the New York case, if the New York courts were to stipulate, for the sake of argument, that some of this evidence shouldn't have come in because it's immune conduct, is the path then open for them to, the argument that it's harmless error? And wouldn't that normally create a state court issue of whether or not there's sufficient evidence to sustain the verdict, even if you don't include this? Or does that automatically and clearly create a federal issue? And, is there any way to imagine the Supreme Court not finding some way to make it, to take the issue?
Yeah, so you're exactly correct as a general matter. I think the best argument would be for the state would be, assuming arguendo that everything involved in this case is that could be considered to be an official act, is the volume of other evidence is such that you can't consider there to have been prejudice, and therefore any error is harmless. The problem with that, as Anna referred to before, is that if you construe the official act stuff semi-broadly, there's actually a lot of it in this case. And I'm not sure the proposition that you just articulated would be true. And the key moment is the Hope Hicks Trump discussion. The prosecution makes a lot of this in their closing argument. Of course, it was a 5.5, 6 hour closing argument that they made a lot of things, right? But this was a pivotal moment in the case, and it is arguably an official act. And so I think that the problem with that is that unless you construe official acts at least a little bit narrowly and exclude at least the parts where the president is talking with his communications advisor about how he's glad they dealt with this, that they prevented this from coming out then, at least so that he'd rather deal with it now than then. Unless you can exclude that, I'm actually not sure it is without prejudice, honestly. Again, it gets to this sort of metaphysical question of, there's a big pile of evidence and some of it may be official, some of it's clearly not official. How do you decide, particularly in retrospect?
Well, and also keep in mind, remember the Supreme Court actually said, even if you find that it's just presumptively immune and that the prosecution has rebutted that presumption, it might end up going up to the Supreme Court and they say, actually, just kidding. All of this stuff we were talking about is absolutely immune, because they, in the way they wrote the opinion, they said at a minimum, the president is entitled for non-core official acts a presumption of immunity. But they didn't actually decide the question of whether they would later come back and say, anything within the outer perimeter is absolutely immune, not just presumptively immune. So that's a huge issue, because they could ultimately, if Merchan says, okay, yeah, this is in the outer perimeter, not core, presumptively immune, but rebutted, it goes up to the Supreme Court, and the Supreme Court says that means the case is thrown out because actually there's absolute immunity.
All right. We are at the outer perimeter of our time. So we are unfortunately going to have to leave it there.
That is a joke that you can only hear on Lawfare Live, and I just want to congratulate Natalie for it. We should always err on including really nerdy outer perimeter jokes.
I'm sure we'll find other useful language, including from this opinion, to work into our everyday speech. But apologies to those of you whose questions we didn't get to. Please come back next week. And we will do our best to get through everything. Until then, thank you everyone for joining us.